Hi, I'm Johanna Weaver, and you're listening to Tech Mirror, a podcast that talks about how humans shape technology and how technology is shaping our society. My guest today is Evelyn Douek. She is an assistant professor at Stanford Law School and one of the world's leading experts on content regulation. Evelyn also happens to be an Australian, and we're absolutely delighted to have her here with us today.
G'day. Thanks very much for having me.
Oh, I love the g'day. Well done. Now, before you absconded across to the US, you were an associate clerk to Justice Kiefel here at the High Court in Australia. Then Justice Kiefel, now Chief Justice Kiefel, our first female Chief Justice, which is really very exciting. How did you go from being an Australian lawyer to ending up at Stanford Law School? I'm sure there are lots of people who'd like to mirror that career path.
Yeah, I mean, I wish it was sort of a more inspiring or intentional story that provided good advice or a good roadmap, but it was sort of all a bit of a very lucky, happy accident, honestly. I did my law degree in Australia at UNSW, and I sort of did all of the things that you do. I went and did my associateship, and then worked for a corporate law firm for a couple of years, and I loved it so much that I had to run away to the completely opposite end of the earth and put as much distance between me and that job as humanly possible.
I did the same thing.
Yeah, right. That actually is a classic story. So I went and did my master's overseas at Harvard Law School, and I had this idea that sort of 9 months or a year at Harvard would really sort of make it clear what I wanted to do with my life, which didn't happen at all. I sort of was getting towards the end of the year and starting to panic about not knowing what to do. And so a friend sort of said, well, why don't you just enroll in a doctorate? That, it kicks the ball further down the road, which is for anyone listening, the worst possible reason to do a doctorate. Like, I really think you got to have a really good reason, a lot of drive, a lot of passion normally to do a doctorate, but that was not my reason. And it turns out that if you want to do a doctorate, you need a topic. It turns out they require you to have some idea about what you're going to research. And this was right around 2016, 2017. When, the fake news crisis was exploding. Everyone thought the biggest threat to democracy was Macedonian teenagers writing articles about how the Pope endorsed Donald Trump or whatever it happened to be that was on social media. It feels like such a quaint problem these days. But I thought this was a really interesting issue, a really interesting problem, and had international ramifications. So that's what I decided to do my doctorate on. And I just fell in love with the topic. I just found it so fascinating. And of course, the field has really exploded. This is something that, is now, there's so much activity happening in. And so, one thing led to another, and I went on the job market a couple of years ago, and that's how I ended up at Stanford.
I love stories like this. So many people come to me and ask for career advice, and so many people, we ask this question of many of our guests, and so few people actually had a clear plan and clear trajectory. It's like, do the things that you're interested in, do the things that you love, and that will lead you to hopefully at least an interesting life and a good career. So content regulation is your thing. I want to drill down a little bit in terms of what content regulation actually is.
Yeah. So I studied content moderation, which is typically what we talk about, where platforms have these rule sets, how they write the rules for what you can say and do online on their services, and then how they enforce those rules. So, the Twitter rules or the Facebook community standards, or, these days the Threads guidelines, or whatever it happens to be. Because everything that happens in the world these days has an online component. There is no social or political issue that doesn't manifest on these platforms in some capacity. Every problem is a content moderation problem. There is no sort of thing that happens in the world that isn't also something that these platforms have to think about and have to deal with. So they have to have rules for deciding, are we okay with this kind of stuff on our services, and what do we want to do with it? So that's where that idea of everything is content moderation comes from. Back even, a couple of years ago, there wasn't a lot of regulation in this space. A lot of it was these private regulators, these private companies who were deciding all of these rules and making all of these standards and enforcing them as they liked. And then since then, basically, I barely know a regulator in the world these days that isn't writing or passing some sort of law to try and rein in these platforms or exert more control over what's happening online. And so that's the interaction between those two kinds of regulation, that private regulation that the companies are doing and the public regulation that the governments are doing, how those work together and what that means for our online life is what I'm interested in.
And one of the things that you've written quite a lot about is your frustration with a lot of the conversation around content moderation, focusing on individual specific issues. So taking down a particular piece of content in relation to a particular controversy, as opposed to what you argue, taking a systems-based approach to content moderation. When you talk about systems-based approach in content regulation, what do you mean by that?
I think it's really natural for us when we think about speech regulation in general to think about this like you have a rule, someone says something, you look at the rule, you look at what they said, and you see if there's some sort of breach of the rule or what the punishment should be or whatever it is. That's how we've thought about sort of speech controversies time immemorial, and that really individualistic kind of approach and a very sort of rights-based, like especially, where I'm sitting right now, like First Amendment kind of individual speech rights approach to thinking about this. And the thing is that that's just like such a poor match for how these systems operate at the scale that they operate online. So in the course of listening to this podcast interview, the time that it takes a listener to listen to this interview, Facebook is going to take down something like over 1 million pieces of content, or it's, something in that kind of range. And when you're operating at that kind of scale, when you're reviewing that many pieces of content, you can't really think of it in the same way as you can with like individual like court cases that can take sometimes months and months and months for the judge to sort of carefully evaluate the evidence. This is operating at a speed and at a scale that is like truly unfathomable. It's really just hard to get your mind around it. And it's at a scale where mistakes are inevitable, right? Like you're just not going to have every single decision be right in that kind of context and when you're operating like that. And so what's much more important is thinking about the systems that are in place in order to sort of review that content and the affordances that you give users in order to create content, how you can sort of provide users with tools in order to sort of moderate their own experience online. And then, what kind of errors do you want to err on the side of making? Do you want to sort of err on the side of more false positives or false negatives? Because again, when you're operating at that scale, you are going to make mistakes. And so I think adopting that sort of systems-based approach, thinking of it much more broadly and holistically, rather than thinking like the answer is always going to be the same answers that we've had in a judicial-based paradigm. And that just doesn't work in this sort of entirely different paradigm.
If I could give you a magic wand and say, you now have the power to implement system-wide reform, what would be the elements that you would want to see getting down into the nitty-gritty?
The thing about that is that it's kind of impossible to say sitting from where I'm sitting. And so if I, had a magic wand, what I'd want is more transparency, more information about what's actually going on. And that's one of like the remarkable things about the current situation in which we sit, is that we have these like extremely powerful platforms doing all of this regulation, making all of these decisions about our online experience. And we know like surprisingly little about how they're doing it and exactly what they're seeing and what their systems are and all of those sorts of things. And I don't think we can solve problems that you don't understand. And so I think part of the problem is like regulators are rushing in and trying to fix things without having a lot of information about exactly what's going on. And so I think, step one is we have to get more information about how, what exactly are the problems that we are trying to solve and what are the most effective solutions to solving those.
Yeah, transparency. Okay, good. Spotlight is always very useful. You can't have a conversation about content moderation, content regulation without talking about Section 230. We've mentioned Section 230 on this podcast before, but we haven't really done a deep dive in what Section 230 actually is. And since we have a professor from Stanford Law School here, it seems like the perfect opportunity for a mini deep dive on Section 230. And why one section of a US piece of legislation is so influential globally.
It's funny. It's this like bizarre situation where you have this like this single provision of the US code that has it's like share now. You don't even need to say like what legislation is from. You just say Section 230 and people know. It's like you don't need to spell out Section 230 of the Communications Decency Act. Like people, it's I go to parties sometimes and someone will ask me like, what are you doing? And these are people in like completely different fields, engineers or whatever, and I'll sort of explain and they're like, oh, is that Section 230 kind of stuff? And I'm like, yeah, actually that kind of is. So well done. So I don't know if Australian listeners and Australian engineers or have the same name recognition with Section 230, but as Jeff Kosseff famously called it in a book that he's written, it's the 26 words that created the internet. And the idea being that it provides an immunity for platforms from liability for the content that other people post on their services. If I go and defame you on Twitter, you can sue me for defamation, but you can't sue Twitter. And the idea being that because Twitter, operates at such a scale, if you expose it to potential liability for everything that's on its services, it's going to err on the side of caution and take down anything that may or may not be a source of liability, and the cost of free speech will be too high. So you could then go to Twitter and say, hey, Evelyn's tweet's defamatory, and Twitter's going to go, well, I don't care if it is or isn't. I don't want to be exposed to potential liability. I'm just going to take it down. And it could have been a really, important tweet. You can imagine it sort of tweets about politicians or things like that, that might be important that we would want, services to protect. And it was this sort of provision that in many ways allowed the fledgling internet to flourish and to create the platforms that we see today, because, it meant that they couldn't be sued for the things that were on their services, and allowed, content to flourish. And so it has been an extremely important provision. Now, of course, the argument is, the reason why it comes up so much these days is, well, that's fine, but it's gone too far, and it has allowed them to act with all power, no responsibility. That they have this immunity, and instead of encouraging them to clean up their services, it's provided them sort of an escape and allowed them to not do that and not internalize the costs of their services.
So this all happened in 1996. So basically 3 years into the internet being in existence. So it's quite a long time ago, but on the other hand, it's not that long ago, was when the Communication Decency Act was first proposed. There was a whole raft of other provisions that increased penalties and liability for indecent communications that sort of came out of this panic about pornography on the internet, etc. The Communications Decency Act was passed. It was then challenged, and basically everything was struck out except for Section 230. And so the idea that Section 230 was meant to be a shield against liability, at the time it was drafted whilst also raising the level of liability for personal posts, etc. This is a controversial question. Basically, since those court cases, there's been conversations about, do we need to reform? How do you actually address this imbalance? And in particular, there were two cases that were at the Supreme Court this year in the US, one against Google, one against Twitter. There was a lot of chatter, a lot of excitement, I think, actually, among the community that we were actually going to see the Supreme Court in the US opine and perhaps drive some change in relation to Section 230 after a couple of decades of commentary and expectation of reform. But it didn't happen. So were you surprised by the lack of commentary on Section 230 in those two cases?
Yeah, so I mean, I think there was a lot of excitement. I think there was also a lot of nervousness about what the court might do.
Yeah, trepidation.
Exactly. Yeah. This is it's a sort of highly technical area. The question in the Gonzalez v. Google case was, does a platform lose the immunity that Section 230 provides when it amplifies content, right? So when YouTube says for you or whatever next video, and it recommends a piece of terrorist content, for example. Now, ordinarily, you can't sue YouTube just because it has terrorist content on its website. That's what we talked about. That's the core of Section 230. But the argument was, well, it's different. It should lose that immunity once it starts amplifying that content. And that's actually like a surprisingly technical question about like, well, what is amplification? How do these recommendation algorithms work? What, who knows what, and what kind of level of knowledge is there involved in that kind of process? And, Justice Kagan in oral argument sort of got a lot of, had this laugh line where she said, we're not like the 9 greatest experts on the internet, right? And she was sort of acknowledging that for the court to weigh in here in this like really technical area and provide a justiciable line of what counts as amplification, but wouldn't catch, for example, search engines where when you're searching for terrorist content or you want to search about ISIS and it provides you answers, that you do, that's this kind of thing that pretty much everyone agreed we want to protect those kinds of answers. Like that's the kind of thing that the internet, the recommendation algorithms can be really good for. Drawing those distinctions is really, really hard. And I think everyone was really nervous that the court was going to make a big hash of it. And I think ultimately what happened was the court itself became nervous that it was going to make a big hash of it, or sort of during the oral arguments when it was sort of interacting with the lawyers from both sides about trying to like understand how these systems worked. And you could really hear the justices like troubled by the idea that these platforms didn't have any responsibility and could be completely irresponsible, but also I think quite scared about how to understand where to draw the line. And so I think, especially after oral argument, listening to them sort of feel, I think, nervous about their capacity to make a good ruling. It didn't entirely surprise me that they ultimately punted.
So I have sympathy for the justices in that instance, but it's also kind of terrifying to me that an inability to understand something is driving a lack of reform or a lack of change. And it's something that we really focus on. A lot of the work we do at the Tech Policy Design Centre is how do you actually lift the bar in terms of the level of debate, the level of conversation, but also uplift public servants' capacities to make policy or regulators' ability to engage. And, I think for me, that particular quote that you're talking about, we're not the 9 experts on the internet, is a perfect example of why we need to be engaging more actively on these issues.
I mean, I completely agree with that, but I think that, there's also this question of institutional competence and like, are judges the right people to be doing this? Or maybe are like lawmakers, so whether it's parliament or Congress, maybe, when they can sit down and have hearings with tech executives or get expert reports and sort of have these conversations and craft, really nuanced pieces of legislations that have like lots of definition sections and all of these kinds of things. That to me feels like when you're dealing with highly technical, highly detailed problems, that feels like a more sort of an approach that's likely to get better outcomes than these judges, many of whom, like, I can't remember the average age, but it's right up there. Weighing in once every 20 plus years on the particular interpretation of a particular piece of regulation. That doesn't necessarily feel like the best way to be crafting regulation in a space that's so fast moving, that's so technical, that has all these other things. So, I mean, I totally agree with you that we can't sort of just plead ignorance because this technology exists and it needs to be regulated. Like, that doesn't mean like we shouldn't just sort of go, it's all too scary. But I do think there is maybe justified humility from wondering, who are the right people to be making these kinds of rules, and do they have the right resources and information at hand in order to make the correct decisions?
You're listening to Tech Mirror, a podcast from the Australian National University's Tech Policy Design Centre. If you like what you're hearing, we would love it if you could give us a 5-star rating, or even better, leave us a short review on your podcast platform of choice. Now, enough interruptions from me. Let's dive back into this episode. In the US, there's this new piece of legislation, no Section 230 immunity for the AI Act, saying that we shouldn't have Section 230 applying when it comes to speech regulation for generative AI. So when we're looking at content regulation and generative AI, what are the things that are top of mind for you?
It's a funny piece of legislation, really, in terms of I don't think many people, it's sort of just clarifying, I think, what many people understand, which is that probably Section 230 doesn't apply to generative AI anyway. So it's like, okay, great. Thanks for clarifying. But I think, one of the things that has been interesting or good to see, I think, is that at least Congress has gotten better, has learned things over the past half decade. When I first started my dissertation and was working on this, this was before it was sort of in the first year or so that we had the first hearings with tech executives. The first time that Mark Zuckerberg was called to the Hill and made to answer for everything he'd done. And back then it was like a big deal. This was it was a Super Bowl news event that these guys were being made to, and they were generally guys being made to show up and explain themselves. And then sort of over the next few years, it sort of became a bit of a yawn event because they were happening all the time. These hearings with various tech executives. And I think we did see, I don't want to overstate it. We did see some improvement for like the level of questioning and level of knowledge. I think also that's on the one side. On the other side, we also saw like an increasing partisanship and polarization of and politicization of a lot of these issues. So maybe some questions got better, but some questions got a lot worse as well because there was a lot more grandstanding and a lot more sort of like if in 2016 there was some maybe partially bipartisan agreement about like Russian interference in the US election and Facebook needing to fix that problem. I think we're in a world now where there's like barely any bipartisan agreement about any of these issues. And I think that really sort of hampers the productivity of these hearings.
Do you think the tone of the companies has changed in relation to these hearings? Because there's been the increase of hearings in the US, but also, a proliferation of these types of hearings in parliaments all around the world. And I think, it is interesting which, in Australia at the moment we have foreign interference inquiry being led by Senator Bragg, and who is appearing at that, who's responding to requests to appear is, a controversial topic. So the way that companies are engaging, have you noticed a shift in that?
Well, I'd be curious for your answer for on the Australian front. Sadly, when I first started this, like I was saying, there was not a lot of action, I guess, not a lot of regulation, and I tried to keep track of all of the regulatory processes that were happening around the world. And these days, every regulator's doing it, and I basically can't keep track anymore of like what's happening in all the different jurisdictions. And so, sadly, I'm not as informed and can't keep as up to date on sort of the Australian issues as I once did or would have liked to. So I'd be, curious to hear how you think it's changing in Australia. In the States, I think that generally the companies have shown up. I think that and tried to be helpful. I think that people were all very impressed with how Sam Altman of OpenAI was much more proactive in getting out ahead of the congressional hearings when sort of congressional interest in OpenAI and generative AI started. He was really proactive about engaging with Congress. I think having watched Mark Zuckerberg and the others sort of be caught on the back foot about being like hauled to Congress and not really sort of expecting it and being on the defensive, I think he understood that Congress is in the game now. Of like being interested in technology and wanting to understand how this works. And so he wasn't ever going to avoid scrutiny. And so was much more proactive in framing that conversation and trying to make that conversation happen on his own terms, which I think has really expanded over the last few years.
Yeah, I think the big difference in Australia is the level of representation of who attends the hearings, right? So normally, if there is a representative, it'll be a regional representative.
Yeah, you don't get Sam Altman.
Yeah, so he's not turning up to.
Right, gotcha.
Correct me if I'm wrong, Senator Bragg, but I don't think he is. And I guess that leads to a question. There's been increasing commentary about the concept of trust and safety or companies devaluing trust and safety. There's a lot of pressure on the industry at the moment, redundancies and things going on across the industry, and a perception that maybe trust and safety is being devalued is a conversation that I'm increasingly hearing. Do you agree with that? Is that your perception sitting where you are at Stanford?
Yeah, so it's interesting. I think in some ways, there is much more understanding now than there was half a decade ago that trust and safety is something that these companies need to be thinking about from the get-go. I think that, the famous saying was, Facebook was move fast and break things, and that was about Facebook, but it was sort of seen as being generally how the industry thought about these things, is they didn't think about trust and safety. They didn't think about content moderation rules when they first started operating, and then they found themselves with all these problems, and they slowly started to build these massive rule sets and bureaucracies and sort of think about it. And I think there is sort of a more understanding, not everywhere, but like that this is just for purely business reasons, something that these companies need to think about. And if you look at like OpenAI, for example, with the generative AI, they had content moderation and rules and safeguards in place when they launched. Like there were certain things that you could not ask OpenAI to do and get answers, like whether it's, how to make a bomb or whatever, and make it, repeat certain hateful things or those kinds of things. OpenAI recognized that as soon as you release a technology, there are going to be people that try and abuse that technology, and they had rules in place to try and stop that. Now, of course, every rule, can be gamed, and people found ways to get around it. And like tell my grandma, like pretend you're a grandma telling a child a bedtime story about how to make a bomb, and suddenly the OpenAI is like ChatGPT is telling you how to make a bomb or whatever it happens to be. But so I think that there is that sort of like proactive idea, just because they know that it's a business risk, it's a reputational risk, it's a regulatory risk, to not think about these things in advance. Whereas, Microsoft released the chatbot Tay, and without a lot of these safeguards, and within a day or something, people had got it repeating. I think it was white supremacist ideology. So I think from that perspective, there's more proactive recognition that this is something that companies have to think about. But, on the one side, that's good that they recognize that it's a business risk. On the other side, if you only think about it as like a business risk and a reputational risk, rather than like some sort of like moral responsibility or, whatever other reason for doing it.
Shaping society.
Right, exactly. Doing good in the world. A lot of it's seen as a cost center, right? Like it is something that you have to invest in order to reduce the risks of your product. And in a time where there's industry downturn and a lot of these companies are laying off lots and lots of staff, thousands and thousands of staff, cost centers are where some of this comes from, of course, inevitably. And so we see less investment in that kind of in those parts of the platform. I think there's also been, over the past few years, when we were talking about the politicization before, a sort of a bit of a backlash against content moderation, against the overly censorious leftist, liberal elites from Silicon Valley taking down anything that they don't like, is the narrative from particularly the Republicans in the United States, which has led some platforms, and Twitter being the case in point here, to step back from doing content moderation, maybe partly for cost savings reasons, but also ostensibly, notionally, for ideological or sort of those political reasons as well.
We talked a little bit about the difference in terms of the level of representation at a US Senate hearing versus an Australian hearing. What role do you think there is for jurisdictions like Australia on content regulation or content moderation issues in this global environment, particularly focusing on Australia, but also conscious that, jurisdictions like India or Brazil, have really strong thoughts on this and how we meld the international nature of these types of regulations with the fact that, most of these platforms sit within one or two major jurisdictions. US, China is what I'm meaning there.
Yeah, I mean, this is obviously a global problem, and regulators everywhere are having influence in positive and negative ways. And, I think that the influence that Australia can have is going to be very different from the influence that India can have and Germany and the EU. Like all of these different regulations have very different kinds of philosophies, approaches, safeguards, democratic norms, economic power, geopolitical power, all of those sorts of things, I think really impact the different approaches and the different impact that these jurisdictions that can have. one of the big differences, the biggest difference, I guess, between like Australia and America, I guess I'd say there's two. The first is, you can't have this conversation in America without the First Amendment getting mentioned. I think that is just, it looms large in all of these debates, both culturally and legally and politically, and in all sorts of ways. The First Amendment gets invoked correctly, incorrectly, in the name of free speech, and on all sides, everyone is claiming the First Amendment mantle because it does really important political and cultural work, I think, and sort of I think the sort of the free speech culture here is something that sort of looms much larger than it does in Australian debates, and I think that sort of affects the window of possibility. I mean, and also legally, right? Like also legally, the options that are available to regulators are very different in the two countries in terms of what would be constitutional. And in America, Australia has more latitude in that regard, and also can pass legislation. We've talked about Section 230, and we've talked about all of these legislative hearings, and we've talked about all of these years of debates and things like that. There are dozens of bills, Section 230 bills. Nothing gets passed because of this polarization, because of this like congressional dysfunction that sees that there's basically very little hope of anything ever getting passed, let alone anything good or productive. Whereas in Australia, stuff gets passed for better or for worse. Legislation can get moved through very quickly. In the aftermath of the Christchurch massacre, I think it was like something like 48 hours that there was
3 days.
3 days that a piece of legislation was passed. I think that's terrible. That's not a great way to make careful tech policy. But the fact that policy can be made does mean that there is an opportunity to make good policy and to provide an example. We see that global regulators and other jurisdictions notice. I mean, we've seen with the debates unfolding in Canada around link taxes and sort of the requiring platforms to pay journalists and media outlets for content on their services. Australia's example gets invoked all the time, and the Australian example of the media bargaining code comes up all the time. So for better or for worse, what Australia does, I mean, it's not going to have the same level of impact, obviously, as some of the other bigger jurisdictions, but it does provide an example.
Minister O'Neill, Minister for Home Affairs and Cybersecurity, who's currently leading a process for a new cybersecurity strategy in Australia. And when she spoke in an event that we held, Tech Policy Futures at Parliament, she acknowledged that very fact, that, the Australian Parliament is a functional parliament, that it does pass legislation, right. That we have the impetus and the demand from the public to be driving change in this space. And I think, it's often something that we perhaps lose sight of in the nitty-gritty of all the things that are going on, how valuable our actual democracy and the functioning of our democratic systems are, notwithstanding the fact that they themselves also need to have some reform as well. But right. They're precious, right. which is really important.
Absolutely. That and healthcare. Those are the two things that I miss about living in Australia, like functioning democracy and a good healthcare system.
Yeah, exactly. Just two little things.
Yeah, exactly.
Evelyn, I'd love to get your recommendations for, books or resources, places you go to keep up to date or that you've found really valuable throughout your career. And I want to give a shout out also to your podcast, Moderated Content, which is a weekly podcast and a lot of fun. So highly recommend it to folks listening to this one. Yeah.
So I was thinking about this and what advice or recommendations would I give for people to keep up in interested in tech policy issues. And, I find myself, especially with the demise of Twitter, as a, place where a lot of content was like, which was where I would go to get a lot of, to keep up to date and get a lot of news. But there just aren't as many people on Twitter anymore, and the quality has really degraded in my opinion, or at least the stuff that I'm trying to find. I'm going to just give a general plug to newsletters. I think newsletters are fantastic and a really great way to stay up to date. So Casey Newton's Platformer is fantastic, and I get a lot of information and news out of that. But like the Washington Post has a great technology newsletter. Rest of World is a technology an outlet, like a media outlet that covers technology in what it calls the rest of the world, so not America, and it has some really fantastic stories about stuff that's happening all around the world that I find really, really valuable. Yeah, so those are the kinds of things that I find really valuable. I think newsletters that's how I start my day every day. Is I go to my inbox and I have all my overnight newsletters that give me the latest in the morning.
I love it. Bring back the newsletter.
Right.
That's the call for the podcast. Thank you so much, Evelyn, for taking the time to chat with us. Really big fan of your work. Would love to do more with you in the coming months and years. And best of luck with all of your work and the remainder of your spring break, I believe. Are you on spring break?
Summer holidays over here.
Okay, summer holidays.
Yeah.
Okay. I just wanted to say spring break.
Yeah.
Fine. Okay. Awesome. Thank you.
No, it's a real pleasure. Thanks so much for having me on.
Tech Mirror is a podcast of the Tech Policy Design Centre at the Australian National University. This episode was recorded on Ngunnawal lands with sound engineering by ANU Studio. Amy Denmead provided invaluable research support. Post-production is by Martin Franklin from East Coast Studio. Thanks for listening. Get in touch and get involved.